But you guys, I'm excited to have you guys here for the Protect Your Content from Copycats. In just about it seems like there's just been a rash of it lately in the VA world, in the coaching world. I've had it happen to friends. I've had it happen to me. I've had it, seen it happening to people I don't know. And I'm not sure that the way that it's being handled is correct on either side, honestly. And so I just thought, you know what, let's have a professional on and let's get some real answers from somebody who really knows the answers. And so I'm thrilled to have Nakia Gray with us. And Nakia has been an attorney and is still probably an attorney. I don't think you just stopped being an attorney. And she has an amazing, she's going to help us with a lot of these questions that you guys have been asking. So Nakia, if you want to give us your, tell us a little bit about yourself, and then we can just hop right into questions. And as we're going, you guys, if you think of questions, go ahead and put them in the chat. We certainly can add more questions to the list that we already have as we're going. So feel free just to ask away. So Nakia, welcome and take it away.
Okay, well, hello everyone. I am so thrilled to be here and to be able to share this information with you. And, as you said, it's for some reason, I don't know what happened at the end of the year, but the month of December was a huge month for these types of issues to come up. And I think we'll see more of it as we all continue to grow our businesses online. There's something about the online world and the free access that people think that we have to information that just kind of, I would say, it just increases the chance for confusion when it comes to protecting content, what we can do, what we can't do, and that kind of thing. I believe, and I've had several conversations with several people over the past couple of months, that sometimes it's honestly just inadvertent. I mean, people just don't know what's right and what's wrong when it comes to copyrighted material and our creative content. So first, I want to just tell you a little bit about me. Again, my name is Nakia Gray. I'm an attorney. I've been practicing. I'm going into my 9th year of practice. And early on, I did a lot of litigation, which was exciting and stressful and all that stuff. But as of late, I've decided to kind of put that aside and really just kind of write my own rules. And I knew that there was this online world out there and that there were probably people who needed some legal advice and some legal help and didn't know exactly how to access an attorney to do that. So I decided in 2014 to really build up an online business. I had no idea that there was this many people that were out there. And so I just kind of started hanging out in some online groups to learn online business, and then found that there were so many people within those groups. There were constantly legal questions. So it's with that I started to create digital courses and to do webinars. I've been a guest on many webinars for different people within the online world, and there's just such a market for it, which I love. Okay, so and I really enjoy helping people just understand it. I think that legal can be scary if you don't know, and people just kind of clam up and we think, oh my God, suing, lawsuits, that kind of thing. And then also, as attorneys, I think we haven't done the best job at having information to be accessible or being reachable and approachable by people. People think, oh my God, if I call her, is she going to charge me $500 just to have a conversation? I think that there's just this stigma around legal help that it's very expensive, and it doesn't have to be. And I think that's what I've really focused on, is finding a way to make it legal help accessible and affordable for creative entrepreneurs. So that's a little about me. So I am here. I want to definitely answer the questions. I've got a whole list of questions here as well, things that just come up. What I do, I don't know if anybody here uses Evernote, but I am like the Evernote queen. I just save everything to Evernote. And when I'm in groups and I see these questions, I just kind of jot them down. There's kind of a recurring theme of things that come up so that I can address them when I'm on these kinds of in this forum within the webinar. So if you'd like, we can go ahead and get started. I can take some from you, Sheila, and then we can take some from people that are on the webinar. And then I've got, like I said, I have a running list of the common questions that people are always asking. So however you want to do it will be fine with me.
Okay, great. Yeah, I don't think there's really a starting point. Is there, like, there's some things like they have a process and there's a starting point, but I don't know enough about it to know if there is a starting point. So let's just really quickly, just maybe I'll just give you a question, then maybe you can propose a question. We'll just go back and forth. So, it's just the basic question. What steps are needed to protect our online and digital content? And to me, I've been told the only thing I have to have is the copyright and the symbol, the year, the name of my company, and all rights reserved. And that pretty much covers the full gamut, but I don't think people understand. Maybe the problem is that people don't understand what that means.
Okay.
So you tell us.
Okay, so first, let me say this, because one thing that is super important, I want everyone to remember this and to write it down. Everything that you create is protected by copyright. So it doesn't matter if you never put that little C, if you never say all rights reserved, if you never announce to the world that you created it, it doesn't mean that it's not protected. The reason why we use the little C and we use notices and we use copyright language on our ebooks and on our websites and that kind of thing, we do that just to put people on notice. It's almost like, I call it the belt and suspenders approach, okay? And I'm a belt and suspenders kind of girl. So what that means is that you have the protection whether you have the belt or the suspenders, and if you have them both, it's just extra, right? So when it comes to creating your content, just the fact that you created it, it's protected. But that little C is just adding that belt to your suspenders. It's just extra. And so the notices come into play. Those are really for the public. That's just letting the public know. But if there is content, whether it's an image that you see on Instagram or Pinterest or on Google Images or wherever you find an image, if you did not create it, it is not for you to be able to use. So that's the golden rule. It doesn't matter whether there's a little C on it and it tells you who created it. If you didn't create it, you don't have the copyright to it and you don't have the right to use it. So when it comes to the steps that we should take, the first is, putting people on notice is added protection. And so I believe, one of the things that people always say, well, how can I prevent my stuff from being stolen? The answer is you can't. You can't stop it, but you can put things into place and you can take measures to reduce the chances and to help prevent it. And using notices is one of the ways that we do that, because there's something about seeing that copyright notice that makes people say, oh, I better not mess with her. She's pretty serious. This is some serious stuff here. So it's something about just seeing that, or I always say, even in your terms and conditions, let's say you've got a digital course or an online program. When people purchase, tell them, it should go without saying, but say, this is my course. This is to be taken for your own personal use. Of course, I'm saying this in very easy language, and it can be easy. It doesn't have to be, the high-level lawyer talk. It can be, this is mine, you better not steal it, or I'm coming after you.
I think you should say that.
I like that. You can have that. You can have that.
Oh, good. Thank you.
That's what you want to tell people, because when you tell people this, then they know, okay? And they understand that that it's not, you can't take someone else's stuff. And so, I believe that just using those notices and putting that out there just kind of sends a message that you take your intellectual property seriously. Now, when it comes to registration, another common question that I get is, well, do I have to register? The answer is no. Like I said, you don't have to register. But let me tell you why I strongly recommend that you register. Let's say that we've got someone writes an ebook and they use it as their freebie and it's on their website. and someone else is like, oh my God, this is a really cool ebook. I think I want to use this ebook. And they download your ebook, they change the name and they change the cover to be, theirs. And they put their name on it. And they start to sell it. You were giving it away and they're selling it. Well, if it came down to a lawsuit, or it came down to a question as to whether or not you wanted that removed, and there's a question as to who was the original author, if you had registered it, there's a date associated with your registration, that's your proof that you were the first and original author. If they say, I don't know what she's talking about, I wrote this, I'm the first person to write it, and there's neither has registered, or the other, let's call the thief, if the thief had registered it, then it's really hard for you to prove that you were the original author. So that's, one of the reasons why we strongly, strongly, strongly encourage registration. The second is because if it gets to court and there's a lawsuit, and trust me, in your little world, you might think, oh my God, is someone really going to sue? Yes, people do. And you do, and lots of people go to court. There's tons of cases and lots of litigation going on all the time for copyright infringement. And so under the Copyright Act, which is the law in the U.S. that governs copyright, there are fines that people get. There are damages that you would be entitled to, anywhere from $30,000 up to hundreds of thousands of dollars for each infringement. And each infringement is each time, it's one infringement for one person to purchase the infringed book. But if 20 people do it, that's 20 infringements. And so you're entitled to statutory damages when you have registered it. If you did not register it, you aren't entitled to that. You're only entitled to what they call actual damages, and that means you've got to be able to compute how much it was. Now that's tough if it was free, because how do you prove that you had actual damages if you were giving it away? But if you were selling it for, say, $9.99 and they sold it for $29.99, then your actual damages are $20 each time. So that's how you would be able to prove your actual damages. But you want to be able to stick them where it hurts, and you can do that by having it registered. And if it's not registered, you can't do that. The other thing I'll say about damages is that the court throws in even more if you can prove that it was willful, meaning they knew what they were doing. Because, the whole premise behind the Copyright Act and all the intellectual property laws is that, this is a nation where we want to encourage the free flowing of ideas. We want people to be creative. We want people to put their things out there. And so when you infringe on someone's right to do that, the courts take that very, very seriously. And, a lot of times people think, oh, it's not going to get that far. Yes, it can. And it does. It does get that far. And you just don't want to go down. You just don't want to go down that road. So, there are two things that you want to keep in mind. One is just making sure that you are protecting your content. But the other flip side is making sure you're not infringing on someone else's. Just be very careful about this. And I know that good intentions are a lot of times behind what happens in these cases. But guess what? The court does not. Your intentions, as good as they may be, they're not going to get you off the hook. And the ignorance is not a defense. It's not. You can't just say, oh, well, I didn't know that was hers. You knew that you didn't create it. So then you should have known that it wasn't for you to use.
Yeah, absolutely. So that kind of goes along with even if it's free and you get it for free, if you want to share it to the world, you need to share it under their same brand, under their same, and say where you got it from and everything.
No, I'm so glad that you're asking that. It's not yours to share. And the cost, whether you paid for it or whether it was free, it doesn't matter. So okay. Even if you get something for free, it's still not yours to share, because the copyright owner has exclusive rights to reproduce, or to use everyday language, to share it. It's up to them whether they want to do that or not. And so giving someone credit isn't enough. Okay, so
Right.
and I'll give you an example. I'll give you an example of this. So let's say, tell me who's your favorite musical artist.
Oh, you would think this would be easy. I'd have to say my daughter. Uh, oh my gosh. I just don't have time to listen to music. Is that terrible? How about let's just go Maroon 5?
Okay, so let's say Maroon 5 has an awesome CD, and they have that CD, and you purchased it. That license that you have is a license for you to listen to the Maroon 5 CD. That's what they gave you when you purchased their CD. They own the copyright to all their music, and they've issued you a license that you can use this to listen to this if you want to. But your license is limited to your personal use. You can't download it and make copies of their CD and then sell them or even give them away. You can't do anything other than your personal use for that. And so, and that underlying law or rule, so to speak, has nothing to do with the price that they are selling it for. Even if they gave it to you, it's still a license that they gave, a limited license that they gave to you for you to listen to their music. And so kind of think about that whenever you're, even if we're getting free ebooks, even when we read a blog article on someone's website, we don't pay to go to people's websites, right? We just read the article. But it is not, it is not for us to reproduce that without the permission of the copyright owner. Now, you are deemed to have permission when they have share links under the article that says you can share this on Twitter, you can share this on Pinterest, or wherever you're permitted to share. That is deemed to be a license to share. But but that's not a license for you to print it, put it in your ebook, and now sell it.
Right. So if you get, so a lot of times I'll get emails from, Marie Forleo or someone like that, and they'll say, please share. That is giving you permission to share. Other than that, you really shouldn't be sharing it in any way. Not even, if I find an article that I think is amazing, and or get an email that's, okay, I guess where do you draw the line, right? So if I get something that's free, and I say, this is really awesome, Nikia would really benefit from this, can I just send it to you, or do I have to send you to their sign-up page? I mean, how sensitive is that, or is there a really big gray line?
I think that there is, permission is key, right? And that's what Pamela just said, which is so true. Permission is key. But I think that it depends on the use. Okay, and so if I have an ebook and you download my ebook and you love that ebook, you should come to me and say, Nikia, I loved your ebook. I'd like to share it on my website. And then I'll say to you, wonderful, thank you so much, Sheila. Here's the link for you to put for people.
Gotcha.
That's the way that there should always be some kind of permission that is given. Where it gets sticky, rarely is someone going to sue you for something, even if you didn't call me, but you put it out there to share. I'm not going to sue you for that because that's probably very beneficial to me. Where things get tricky is where people, like your ebook, change the name and now they're selling it as their own. I mean, that's really the problem. So a lot of us, people are people you can share. But it's where you are actually stealing or copying from someone that makes it, that's where the key where it happens. Getting permission is always the best way to do it.
And I've asked for permission to share things in the past. I've never been told no.
Right.
So if it's not something that's being paid for, and a lot of times people will say, feel free to share this. I mean, Derek Halpern on every one of his videos says, if you like this, share it with somebody. And so does Marie, and they make it a point to say, this is what you can share. So it's almost like they're putting the C with a slash through it on their stuff, saying, this is your permission to share it, but then they have their other items, obviously, like B School, where they, you just don't share it.
Right.
So let's go to another question. So you said that everything that we write is ours. We don't have to have the copyright. But one of the questions they asked are, what are the terms and policies that we need to put on our website? And I see this a lot, and I have had even when I'm building the site, sometimes some of the themes even have a terms and conditions page built in where they want you to put in terms and conditions, and you have to put it in the footer and everything else. So I'm wondering about that. Do you have to have terms and conditions, and are there certain things that you should have that for? Like, I have a course that's getting ready to come out that has been on my mind. How am I going to protect this course? Do I need to send it out in the email, the terms of use, whatever? Or what do you think about that?
Okay, so anytime you have a website, you should have terms and conditions. Some people call that terms of use. It's the same thing. You should definitely have that. That just explains to people how can they use your site. Okay, it's almost like this is just the house rules. Okay, this is what you can do. This is what you cannot do on my website. Now, some people choose to have terms of sale, so to speak, or terms and conditions for a course in that as well. My personal preference, and when I am doing this with my clients, I tend not to do it that way. I believe that at the time that people purchase your course, that is where you should explain to them the terms of using that course. Don't expect them, if they've been following you and they opted into your website a year ago, they're probably not reviewing your terms and conditions every time that they go to your website. So if there are things that I need to know about this course, I want to know, you should tell me that at the time that I'm paying you for the course. So I usually draft a separate set of terms and conditions for a course that I may call that a terms of sale. If it's a group course where there's going to be any kind of forum, then I would have a membership agreement that says here's what you've got to do in order to remain a member of good standing in this program. You can't steal anybody else's stuff. You can't steal my stuff. Anything that you post or that you submit, you are giving me a license to use it. So you can't later come and sue me for copyright infringement. And so all of those kinds of things you want to have in your membership agreement. So you definitely want to have terms and conditions as to how people can use your site, and that's a great place for you to put information about sharing. So you may say in there, everything on my website, all of my blog posts are protected by my copyright. However, I welcome you to share them if you do, here's how you can share. Here's the link back to my site, or however you want to do it. Or you may say, please contact me at this email address if you'd like to use any of the information on my website. So that you may just want them to contact you. But that's where you put all of that kind of information. But I think you definitely want to have, it's just my own preference, and I'm not saying it's wrong if you do it the other way. I just think, whenever I'm doing things for clients, I want it to be the best possible way. We want to make sure that every person who takes your course knows everything that they need to know. And the best way for me to ensure that is to have them read some terms at the time that they pay.
Right. I think that's really smart. And that's something that I have actually been slacking off on quite a bit until this year. I have a virtual assistant network, and in the past I have not had them sign a terms and conditions until recently. And you don't think about it. Like you just said, if you have a group, like I have a private group, I'm sure several other people have private groups, are we having our members sign, saying what the terms of the group are? I didn't think about that. So 2 questions for you that kind of aren't on the list that came up. One person said, what about sharing things that are on Facebook and Google Plus and things? And I think the basic answer to that is if you post it there, you already know it's going to be shared. It's got the share button. So that's obviously not copyright infringement by sharing that way. But the next question would be, where do you get these terms and conditions, terms of sales, membership agreement? And I really like house rules. I might have to take that from you, too. Say, these are the house rules. Because I think that's pretty clever. So it probably doesn't have to be called terms and conditions. It could be something different. But where do you find these things?
There are tons of lawyers that draft them for you. There are lawyers that sell them as templates. I do that. In 2014, I did them a lot of one-on-ones, and it just got to be too much for me. So this year, I am launching right now an online entrepreneur pack that has the templates for you to customize them as you need to use them on your websites. So, and then there's tons of, there are templates everywhere. Here's what I want to say. Do not copy someone else's terms and conditions or privacy policy. Do not do that. That's copyright infringement in and of itself, because you're copying from someone else's website. So resist the urge to do that. Although lots of us are in the same businesses and the way that we operate may be the same, but whatever the terms and conditions or privacy policy is on your website should match how you actually do business. So, for instance, one of the things that I put in my privacy policy is I explain to people what my client does with their financial information. So I specifically reference whether we're using PayPal, whether we use Stripe, whatever it is that we use to store your information. If you copied mine and you don't use those payment processors, now you're lying on your website. So don't resist the urge to do that. And I know people, legal is one of those things that people just, we know that we need it, but we don't really want to pay for it. And so resist the urge to do that. Really just pony up the money. It's a one-time thing that you're going to do that's going to last you forever and ever and ever and ever. And it protects you, in terms of the membership agreement. I don't want to totally scare people, but it's my job to tell you what could happen, okay? What's the worst that could happen? So let's say that you've got a group program, and one of the people in your group steals content from someone else. Someone posts, here are 3 ideas of my program name. What do you think? This is in your Facebook group. And you have this, bad Sally. She's in the group. She only took your course to get information and get inspiration from other people. And she takes, this person's idea. Well, the last thing that you want is for someone to blame you for that and say, had I not taken your course, you're responsible because you let Sally in. You let Sally into this group, and now she's stolen from me. So you want to have a membership agreement that says, here are the rules. You can't steal. You can't do this. You can't do that. But if someone does, I'm not responsible for other people. You can't come and sue me if someone does, steals from you, or God forbid finds where you live and comes to your house, and whatever happens, I cannot be responsible. And so, of course, this happens a lot. We hear of these things happening all the time. America, I love my country, but America is one of the most litigious places. I mean, if someone slips and falls, we sue the place, even though they didn't put it there. This is how people think. So you want to make sure that your business, remember, because we're online business owners, we sometimes forget, because it's not brick and mortar, we don't think of all of the insurance that we would have, so to speak, if we had a physical place. If you had a physical store, you would have all kinds of insurance that says, if you come in here, if you slip and fall, if you jump on these trampolines and you break your neck, I'm not responsible. Think the same way as an online business owner. What's the insurance that you need for your online business? And that's where your membership agreement, your terms and conditions, all of those things are your insurance to say, not me, you can't sue me if something bad happens. The other thing we didn't talk about, but it just popped into my mind, is disclaimers. Those come into play there too. I'm not making any guarantees. That is, huge. The if I've got a testimonial that one of my coaching clients made 6 figures in her first month working with me, that's not normal. That's not going to happen to everybody. You can't sue me if that doesn't happen to you. I know this stuff seems obvious and people should just know it, but they don't. So that's where your terms and conditions are very, very important. If you're doing anything, and for all my health coaches, or if you're in the health field, you've got to have the right to, I'm not a doctor. If you get cancer, You can't say it's because I told you to drink these avocado smoothies or whatever, whatever it may be. So you want to make sure that you got, all of those things. Another thing that we always put in terms and conditions are affiliate links. You got to make sure under the Federal Trade Commission, you have to tell people when a link or a product or service that you're referring to them, that you're going to get some kind of kickback to that. I can't tell you how many times I go to people's websites, I read this great post about this planner or whatever the product may be, and I link to that site, and I can tell it's you can see that it was an affiliate link, and they didn't tell me that. That's not a big deal to me, but for some people it may. I just think that you should just be transparent and tell people, by the way, I am an affiliate. And so that's one thing, just kind of put that out there in your terms and conditions, to say, here is, if I'm just because I'm recommending something doesn't mean that I am doing it just for the money, but I want to let you know some links here may be affiliate links, and you just want to let people know that. Uh-oh, you're mute. We can't hear you.
Sorry about that. So a couple questions. I'm trying to keep up with everything and take my notes too. So a couple questions came up while you were talking about that. There are a lot of stock language use terms out there. So if you do find something that you're going to copy, make sure that the website actually says on there, this is for you to copy, right?
Right.
Because there's a lot of places that actually do offer that for free. And then you kind of have to just maybe do your research to find out if that person that's offering it free is offering it the right language free.
Exactly.
No guarantee that free stuff is going to cover your butt. Also wondering so going back to registering your content, there was a question asked earlier about where do we go to register? We would call you, correct? Is that we would need to call an attorney, or how do we register?
You don't have to call an attorney. It is easier, of course, if you have the guidance of an attorney to do it. But usually it's something that once you learn how to do it the first time, you can pretty much do it yourself. You want to register with the U.S. Copyright Office, which is www.copyright.gov. And it's all done right there online. And it's I don't want to say fairly easy, because of course I'm a lawyer, and I've done it a million times, but it's not that hard. So if you I would say either just talk to an attorney to make sure that you're filling out the application properly and that you've done it the right way, but it's definitely something you don't need to hire an attorney to do. You can, but you don't have to. Great.
Another question: how do we set that up in a group? The terms and conditions, or the disclaimers, you can obviously just put in the description, which I never thought of. That's really clever. But the membership agreement, how would you manage that in a group? I mean, I know there's some groups that have more than 4,000 members. Would you create a document and have everybody type in their name, or personal message everybody who joins, or how would you have a group terms and conditions, I guess, or membership agreement?
I would either have it in the description at the on Facebook, where you have a description of the group and you can say, here are the rules, and if you click to be added to this group, you're agreeing to these. If you do not abide by these, I reserve the right to kick you out of my group. Okay? So you can either do it there. For me personally, I do mine all of my groups are related to some opt-in or some product that they may have purchased from me. So it would be in those terms and conditions that say, okay, you've purchased this course. With this course comes a group, and in that group you can do this, you cannot do this. So I may have it there, but also it's, again, belt and suspenders approach, right? So you can put it there, and you can put it on that front page of your website. It doesn't, these kinds of terms and conditions, they don't have to be signed by people in order to be effective. So you can simply state, how many times have we gone to websites to say, your continued use is deemed to be your acceptance of the terms and conditions. So don't worry about trying to get them to sign it. If they continue to use them, or if they sign up after they've read, you've been on those checkout pages where it says, click here to to accept the terms and conditions. I know a lot of times people just check it and we don't read it, but start reading those, people. Read them. but that's where you want to do it. You can put it right there, and you can put it in the description of your group.
Great. Okay, so we will come back to, so right now we're talking about how do we protect ourselves. We'll come back to how do we find out a little bit later. So let's keep on the same topic. So the next, so if the website is using a black horse, is it somehow legal? I don't know that term, black horse.
I don't either. I'm not sure what you mean by that. Who asked that?
Denise asked that, and I'm not sure. So Denise, maybe we need a little bit of additional information. So let's see. If you register in one country, then is it applicable in other countries? So that's a good question. If your terms and conditions, I assume there's the country of the internet, right? Is that true? Like there's the country of the internet, and if you're using the internet, then those terms and conditions will apply. Correct? That's kind of my thought on it, but.
Well, the internet is worldwide, right? It's the World Wide Web, but you govern. It's your own little country, okay? Your website is your country, and so you set the rules for your. It's a dictatorship. It's okay. So you say this is what happens on my website, and so anyone who uses my website, this is how it is to be used. If typically we do have at the end of the terms and conditions something about if there's any dispute that arises from this, and we end up in a court of law, which hopefully that would never happen, you would be submitting to the U.S. jurisdiction or whatever country you're in jurisdiction. If you can't sue me, if you're in Canada and you somehow there's a dispute between you and I over my terms and conditions, you can't sue me in Canada. You have to sue me here. And so you'll usually have some language like that.
Okay, that's what it says at the bottom of my contract too. So, all of my contracts say if there is a dispute, they will be handled in the state of Utah in the United States.
Right, exactly. Now, I believe that there was a question. Okay, Cheryl, I believe that Cheryl's question is about if you register your work for your copyright protection in one country, is it applicable for all other countries?
Oh, gotcha.
So
okay.
Because that's a great question, and the answer to that is maybe. There is an international treaty called the Berne Convention, BERNE. You can Google it, or you can go to www.wipo. I don't know if it's .net or .org, but it's the World Intellectual Property Organization. And so there's this convention of all of these participating countries that said, okay, I want to be in, I want to be in, I want to be in. And what they decided is that if any of their residents received copyright protection in one country, they would give reciprocity to that in their country. So, for instance, U.S. and I always use U.S. and Canada as examples because I haven't memorized all the countries. There's tons of them. But U.S. and Canada are both members. So that means that if I have registered lots of work here in the U.S., so my work is also protected by copyright in Canada because I registered in the U.S. and both of them are parties to the Berne Convention. So you want to check the Berne Convention to see, one, if your country is a member. If your country is not a member of the Berne Convention, then you may want to register your work in the country where most of your business is happening. So if you live in a country, I don't know, country A, that is not a part of the Berne Convention, but a lot of your work is shared and used and distributed amongst the U.S., then there's nothing at all that stops you from registering your work in the U.S. And I could do the same in country A if I had business and clients in country A and I wanted to make sure that my work was protected there. You can register your work in other countries.
Okay, very good to know. I think we got the questions that were in.
Oh, good. So I called that. She said,
yeah.
That's what I thought. So
You did. Yeah, I just don't know enough about it. I think this is why this is really helpful to me. I'm sure it seems like it's really helpful. Everybody's really active, so I'm sure it's really helpful to everyone else. So, let's see. So, if a person okay, so now we'll kind of switch. So we kind of learned a little bit about how to protect ourselves, what we need to do, registering, things like that. So switching gears to now. Okay, so the ways that we can find out are obviously using websites like, oh shoot, I'm having a complete blank.
Copyscape.
Copyscape. That's how you can find out if you suspect it. There is a situation where I suspect one of my products was taken. How do you? What is your next step if you suspect someone or you find someone has taken your content? What is your process? Now this would be for the U.S., right? We would have to have lawyers from all over.
Yeah.
So let's just do a general. This is in the U.S. In other countries, you'll need to talk to lawyers in your countries. But from your perspective in the U.S., what are the laws? What are our steps that we take?
Okay, so I'm going to answer that in two parts. The first is what you can do to find out if someone has stolen your stuff. There are tons of resources out there. Copyscape is one of them. I always tell people a good old-fashioned Google alert is like free and easy. Uh-oh. Sheila, are you there?
Yep, I'm here. Sorry.
Oh, okay. A Google alert is a great, easy way to do it. And so you can just set up a Google alert with some key phrases or some things that you may say that are unique to you or unique to your program or unique to whatever it is that you put out there. And you'll just get an email every day. And I've had tons of clients call me and say, oh my God, I can't believe this was so easy to find, and they do a Google alert and they get an alert where someone has put their exact ebook on a website. So, that's another very easy way to find out. So let's keep going. So let's say that let's say you set up the Google alert and you get one and you find out, you go to the website and it is your article, your information, your course, whatever it is, you find out that it's there. So here are your options. The first thing you can do is you can simply send or have a lawyer send. I prefer for you to use a lawyer here, and I'll be very honest with you when there are things that you don't need a lawyer for and when you do. I think that there's something to be said for someone getting a letter from a lawyer. They take it a little bit more serious than if they get a letter just from a business owner.
That's true.
But if you can't afford a lawyer, then by all means you can still do this. So you're going to send a cease and desist letter to that person, and you have multiple options. You can say, look, here is this is on your page. This is mine. I created it on this date. It's protected by my copyright. If you did register it, you can even say, I registered it on this date. If you didn't, just skip that part. You've got 1 day, 48 hours, 1 week, however long, to take it down, and we can just squash this and move on with our lives. Or you can say, you must pay me. You've now infringed on my copyright, and you need to pay me $5,000, whatever it is. There's multiple remedies with a cease and desist letter. Or you can say, you know what? I am so upset about this. I'm not even going to send her a cease and desist letter. I'm going to go right to a takedown notice to her internet service provider to get this off. I want her site taken down immediately.
Oh, wow.
And so, yes. So under the Digital Millennial Copyright Act, that's the DMCA, you've probably seen DMCA or takedown notice, you have the right to contact the internet service provider or whoever's hosting that person's website and say, there's material that you are hosting on this site that is copyrighted by me. I did not give permission. I want it taken down immediately, and they will take it down immediately, no questions asked. And so
that's kind of dangerous. Don't you think somebody could do that to you?
Someone could do that to you
Maliciously.
Well, they could, but you do have to show in the takedown notice. You have to show that you have to show proof.
Oh, okay.
You
So
can't
they
just,
don't just do it, no questions asked. You
yeah.
actually have to show some. Okay, that kind of scared me. I was like, what if somebody hated me?
It's a no questions asked standard, but in the notice, there's a requirement to show copies of either screenshots of the website, or you've got to show, here's their site, here's my material. So you've got to do that. You can't just send an email that says take it down. So, so some people opt to skip the cease and desist step and go straight for the takedown notice. Some people may say, I'm going to give you an opportunity. Here's a cease and desist. And you can do it that way. I'll give you an example of a case that happened, I think maybe a year or so ago. There was PR Daily, which is, a pretty reputable publication that we all know about. They published a blog article, and they used an image that they got from Google, and they didn't bother to get permission. They just went on Google, and you would think that they would know better, but they didn't. And it was literally just a picture of a downtown area in, I want to say the state was Nebraska. And so they were just writing an article about great places to eat downtown, and they had this picture. Well, a couple of months later, they get a letter from a lawyer. The person who actually took that photograph and who owned the copyright to it was demanding $8,000 from them, and said, you stole this from me, and you owe me $8,000. You owe my clients $8,000. We want you to take it down. You owe us $8,000. So PR Daily says, oh, I'm so sorry. I didn't realize it was yours. I'll take it down immediately. The article didn't even do that well. According to Google Analytics, only 100 people actually even read the article. The lawyer said, we don't care. You owe us $8,000. Now, they ended up settling the case, and they settled for, I want to say, between $3,000 and $5,000. But the point is, that happened, and they had to pay that money, because now they could have gone on, iStock Photo or something and got a picture of Nebraska for, a couple bucks. But this ended up costing them thousands of dollars, because that's what happens. And so when people get lawyers involved, that's what lawyers do sometimes. Sometimes they're just going to demand money. And so you can either give in and pay the money. Now, of course, PR Daily had the option to say, hey, go kick rocks. I'm not paying your lawyer anything. But by the time they paid for a lawyer to fight this, they would have spent that money anyway. So they probably just said, forget it. Just settle the case and do it. One more thing I want to say, I don't think I said this. With the cease and desist letter, you want to have in there some kind of affirmation from them to sign and send back to you, agreeing to do what you told them to, what they said that they're going to do. So you want to have something in there that says, sign this, that says you'll remove it right away, and I'll go away, you go about your merry way. So you want to have something, because you've got to have some closure to that. If you don't receive it back within those days that you've given them, then you may want to go ahead and proceed with the takedown notice.
Wow, that's unbelievable. And, somebody probably lost their job over that, or some people.
Oh, yes. And that happens all the time. It happens so much. It's so common. It happens. So when you're looking for the perfect photo or image for that blog post, create it yourself. Go on PicMonkey, go on Canva, do it yourself, or, use the stock photo sites. There's tons of them: Deposit Photo, Big Stock Photo, Can Stock Photo. But I will say about the stock photo sites, be very careful with those as well, and read the terms and conditions, because they are a license. They are not transferring copyright ownership to you. And so with a license, they determine how you can use it. So you've got to look at the licensing agreement and the terms and conditions for each site. I will tell you, Getty Images, stay away from Getty Images. Getty Images are notorious for tracking photos that they give you, and if you misuse it, for a lot of these sites, they will tell you in the licensing agreement and in the terms and conditions that you have the right to use the image for a non-commercial use. So that means if you put it on an ebook that you're selling, that's commercial. And so if they find out, they're coming after you. Getty Images has put a lot of entrepreneurs out of business by suing them because the entrepreneur didn't understand the license that they were given with those images. So be very careful about those.
Yeah, yeah, images are probably, I would say probably more than content, images cause more problems than anything else. Okay, so the question was asked, there's a lot of content curators out there. Is this legal? So there are ways to curate legally and ways not to. And while you talk about that, I'm going to let my dog out so
Okay.
you guys don't have to listen to her bark.
Sure. Yes, there are lots of content curators out there. There's Creative Commons is a really popular one. And yes, you can certainly use those. Again, always go back to the terms and conditions. Make sure that you read them, and make sure that you read the licensing agreements that are there. Even with the content curators, some of them are transfer or assignment of copyright, and some of them are not. Some of them are simply a license with a certain a particular type of use. So I'm going to keep going, sending takedown. Oh, yes, Pamela, you are right. I'm glad someone else knows this. Getty Images, they are notorious for sending those notes. I mean, I think that they have a department that just does that. I mean, they really, they definitely continuously do that. Oh, yes, who is? Perfect, Pamela, thank you. When you want to use a who is lookup, that's what tells you who is hosting the site. So if you are trying to figure out who is the host of the website that has your content, you want to do what's called a who is lookup. Let's see, what else do we have here?
Yeah, another question about what if you have called, emailed, oh, this is for if money is owed. Let's ask this at another time. This doesn't have to do with copywriting, but if we have time at the end, we will ask this. We're already into an hour, but that's a good question. So let's ask that another time. I think. Okay, so just one more question here. In recent events, a well-known coach was the victim of a digital theft by someone in her own community. The coach wrote a blog post naming the person that stole her content, a whole product, and was selling it as her own. She also made it known on social media and explained that her attorney advised her to do so. What are your thoughts on this directive? Because personally, there's other things that could have been handled. In my personal opinion, I don't think you need to take the person and drag them across the grate. I think there's other ways, but that's just me saying that's not the question. So what are your thoughts on this directive? Posting, you know, everywhere, hey, this person stole my content. And would you consider the sound advice from her attorney, and would you advise your clients the same, why or why not? So this is a really good question that just gets right down to it, because we've seen it happen. I've seen it happen several times actually recently.
Yeah, I've seen it happen a lot too, and you know, my opinion is that that's totally up to the person. I mean, as an attorney, I think that, you know, it depends. You know, it depends on you, and I think that in certain instances, I think I know the situation that you're speaking of, and I think in that case, this was so blatant and so egregious because this was a direct copy of a program, and so there was not malice behind that person's choice to do that. It was really from a place of wanting everyone to know, beware with who you're dealing with here. And so I think that if it's coming from that place where you're really, you know, I see that, you know, in these groups, I see this kind of stuff happen a lot. People out people all the time. And so, you know, I really am not going to speak on to whether or not that's the right thing to do or not, because I think every situation may call for a different way of handling it. But you've got to be very careful. You know, everything in life, especially in my life as being a lawyer, always comes down to the terms. You know, whenever you hear me say terms, conditions, agreements, contracts, everything that we do is governed by something. And so you've got to be very careful. What, you know, about what are the terms and conditions of your relationship. Every relationship that you have should be governed by some kind of contract or something like that. And so there are, I have drafted lots of membership agreements where I put in there on behalf of my clients that no matter what, you can't say anything bad about me, about my client, because this is their livelihood. And so because many people don't read, you've now signed up for this and you've agreed to that. So if my client had done, if my client is dragged through the mud by you, I'm coming after you for breaking that agreement that we had. So you just got to be very careful about that kind of thing. I think part of the question was, can the person who was the victim of the infringement be sued for defamation? That's a two-part question. Anybody can be sued for anything. I can sue you for defamation if I want. Will I be successful? Maybe, maybe not. So I do think the answer is yes, she could be sued, because people sue people for anything, whether they have a legal claim or not. Would she be successful? Absolutely not. The number one absolute defense to defamation is truth. It's not defamation if I'm telling the truth. It's defamation if I'm not telling the truth. So if this victim of infringement honestly was, telling the truth, and that this person did steal from them, there's no defamation claim that's going to succeed. However, I'm going to give you legal responses, and I'm going to give you practical responses, because legally, absolutely not. Practically speaking, it's dangerous, right? Because that doesn't mean that they won't. The person who stole, you already have some idea of the kind of person they are because they stole, okay? So this is a person that could very well sue you and have even though their claim is baseless, they could sue you and just make your life a pain in the butt, because now you've got to pay to hire a lawyer to fight their crap. Even though they're not going to be successful, lawsuits are very expensive, attorneys are expensive, and just the time and energy that's taking you away from your business, you've got to weigh the cost, do a cost-benefit analysis. I had a client that called me about, there was a blog post that she had written that another publication had reproduced, and they didn't give her any credit for it. And she was just outraged and just insane and wanted me to write the cease and desist and da-da-da-da-da. And it's like, okay, let's calm down and we know legally what our rights are, but let's think practically. They've got, 5 times your readership. Do we really want them to take it down, or do we really want them to give you credit and link back to your site so that you can get those people on your list? So let's do that instead, and that worked out. So sometimes you've got to think about what's your end goal, and let's just take a step back and see what is it that you really, really want to portray here. And so although there's lots of times there's all kinds of legal remedies that are available to us, and you are absolutely right, and those are your rights and all that, but you've got to decide, what do you really want out of this? And so I think in that case it is, every case is different, but I think for each one you want to just do that analysis. What is this costing me? And what's the worst that can happen?
Yeah, I think when you take a look at that, I've actually had something happen to me recently that I'm still trying to get over. And I think once you look at, like you said, the end goal, what you want out of it, and how much are you willing to invest in it, not only financially, which could really suck the life out of you in and of itself, but you're feeding that anger sometimes, which can take away from your business, can take away from your clients. It can really just eat you up and tear you apart. So I think that's excellent advice. Take a look at the big picture. Do your little stomping around, throw a fit, because I know I would throw a fit. If I found out somebody took my valuable content and copied it and made it their own, I would be really upset. So once you get over that, beat on a pillow, whatever, go for a run, whatever it takes, then really put your head back on, calm down, and decide what you want to do. And then, like you said, every case is going to be different. Every situation is going to be different, because the way you react, the way other people react is going to be different. It's always going to be, it's not always going to be clear cut. So those are the questions that we had. Are there any questions that you think we might need to cover quickly before we tell them about your awesome trademark? Because I want to ask you questions about that too. So.
Oh, sure. Let's see. We talked about protecting online content. Can someone use it? Oh, okay. So these are. We didn't do a lot of talking about music, and I do want to do these two questions. One question is, can I make a mix of different songs and put them on a CD for my live event? And the answer to that is no. That's a great question. And the answer to that is no, because music is protected by copyright as well. And so when we talked about this a little bit with our Maroon 5 example. When you purchase music, you are purchasing it you have a license to use it for your own personal use, and you cannot then make your own CD of Maroon 5, Katy Perry, Beyonce, and everyone else, and then sell it. You can't do that without the permit. When I say you can't, I mean without the permission of the copyright owner. And another question, this comes up a lot with people in videos. Can I use different songs as background music for my videos? That's another thing that I see a lot of people making that mistake, and the answer to that is no. You cannot. It's protected by copyright. But I will tell you a great resource. Pond5, the number 5.com has royalty-free music, and they have so much. I can sit there all day and just try to find the right types of music that I want to go be on the background of my videos. So you want it. They're almost like the stock photo for music. And even video clips they have there as well. So that's a great resource, but you want to be very, very careful. Now, in the grand scheme of life, is Beyonce, going through each of our websites trying to find any of us using her music? Probably not, but you just got to be careful.
I think when it comes to music, you really need to be careful, because my daughter played a piece on the piano, and we went to post it on YouTube to share with our family, her playing it. And YouTube said, you can't. That song is copyrighted. And I'm like, what? So yeah, I think actually when it comes to music, you're going to get caught a lot quicker when it comes.
You're right. You're absolutely right. Especially on YouTube. YouTube is very, they are very good about that. I mean, I've seen, I've gone on different, here's I'm going to tell you all my secret vice. Don't judge me, but I am. I go on like a lot of the entertainment gossip blogs.
Uh-oh, you're calling yourself out, girl.
I'm calling myself out. It's the one thing. It's my one bad thing. I don't do reality TV, but I do sometimes go on those gossip blog sites. And so if you're ever on some of those, when the story first breaks, they'll have a video, and the next day it'll be gone. I mean, because YouTube will snatch. I mean, they take that stuff down, and you'll go on that blog site, and it's like, oh, it's gone, because they are they're like, they must have people watching 24 hours a day for those kinds of things, because I've seen it happen all the time.
Wow. Okay, so let's ask one more question. I know we do have several VAs on, and we have several clients on as well. So if in a virtual assistant situation, either the client owes the VA money, or a subcontractor owes VA money, or a client feels gypped, if you have done everything that you can to get your money, to get paid, to get your product back, whatever it is in that situation. So you've done emailing, you've called, you have sent invoices, you've done everything. Are you pretty much then to the point where you need to contact someone like yourself for help with that? And is that something that you would help with? Or is there a collections office that you should go to? Is that a better step?
I think, here I'm going to give you a legal answer. I'm going to give you a practical answer. Legally, you're entitled to your money, and people can't just rip you off, right? Legally, you're entitled to it. Practically, we're going to go back to that cost-benefit analysis, and how much is it really worth to you? So if someone owes you $300, I can tell you that I rarely would draft a letter for someone for less than $150. Probably $150. If it's very, very short, maybe $100. So are you going to pay 150 to get 300 that you may not, and they may ignore, if they've ignored all of your calls and your emails, they may ignore my letter as the lawyer. So you got to decide, when is your breaking point, if you're just going to say, you know what, I'm just going to be, karma will bite her in the butt sooner than, but I'm not going to spend any more money, time, or energy going after it. Now, if we're talking about $1,000, that's different. That's a lot more money, and and a lot more is at stake. So it may be worth it to you to hire an attorney to do that. But I think that a lot of times the letter from the attorney kind of gets it done. And then going to court is the absolute last resort, because that just takes so much out of you. It just takes so much out of you. And when we're dealing with online, I mean, you could be in California, they could be in New York. Do you really want to go through, all of that?
You lose. Well, here's the thing,
if you lose? There's no guarantee.
And you made them fly from New York with their attorney, or hired an attorney. Hopefully they hired an attorney in California, but chances are they hired one locally. They flew them. You could end up paying their attorney fees, their travel costs, and everything else. So really it does come down to, I like your practical advice. I believe in really looking at practical advice. So I love that you give us the legal and the practical advice. I think that's priceless right there. Brilliant. Great answer. Okay, so let's see. Great advice. See this thread below. Am I missing something? You guys, if I missed something, put it in here while we're talking about this next topic. If we missed any questions, be sure and post those there. There's, it's hard to, I have to get really close, you guys. My camera is really weird. Like, to be able to read what's going on, I have to like stick my face in the camera.
I think that she's directing you to, this was in response to the social media shaming and whether or not it was appropriate.
Oh yeah, I think it comes down to the people involved, and it's I try and stay out of all of that, any of that kind of stuff. So, and everybody would handle it differently. And we don't know, none of us knows what happened before that post was made. So it was made for whatever reason. She felt justified in it, and then whatever happened, happened. And let's not drag it through the mud even more. So let's talk about trademarks.
Yes.
Because I have, how many logos do I have? Oh my gosh. I think I have at least 3 that I have considered trademarking. So let's talk about trademarking, and you tell us how best you can help us with that, because that goes right along with copywriting and is probably more important, because I know I don't want my logos that I worked really hard on creating, that I'm promoting all over the place, to be stolen. So let's talk about that a little bit, and I'll watch for more questions.
Okay, trademarking is huge, and that's really the crux and the stock of your intellectual property. That's really what your brand is all about, because it is how you are seen in the marketplace. Okay, so trademarking your logo, your business name, if you've got a very creative or unusual name, names of programs. I've seen some awesome names of programs that I'm like, you've got to trademark that, because you don't want someone else to come along and take that from you, or to or how think about great example. Let's say you've got a awesome name for a program, and what if one of the students in your course decides that's so cool, I want to get some T-shirts made with the name of that, and they make T-shirts. They use your logo and they make T-shirts and start selling them. That's the kind of thing and this, I'm giving you real examples. This is not a far-fetched idea. This kind of stuff happens all the time. If it happens to Louis Vuitton and Gucci, certainly people do make counterfeit goods or try to knock something off all the time. If they do that to the big guys, they'll definitely do it to little old us. So you definitely want to trademark. Trademarking is a lot more difficult, a lot more expensive than copywriting. Trademarking is something that I recommend you do when you're really serious, when you know you're in this for the long haul. Sometimes I think people may trademark a little too early because you're not sure, is this even going to work? Am I still going to want to do this in a year or so? So I would say trademarking is for that entrepreneur who's been at this for a while, who's put their brand out there, has gained some great traction and is ready to really kick it up a notch and wants to really develop a global brand. And so if that is you, then you are definitely ready to, officially get in there and trademark your brand. Before trademarking is the search. This is where a lot of people go wrong. You've come up with this awesome name, but you didn't check to see did someone else come up with that awesome name before you, or is that name that you've come up with too similar to another name that's already trademarked by someone? And that's where that can really put you out of business. Trademark infringement can really put you out of business.
Well, and you'd be surprised who would come after you, because I'll just give you an example. This gal that I work with, she makes perfume in her kitchen sink. And the big company starts with a P. Now I can't think of it. Like this huge company. I'm trying to say Palmolive, but I know that's not it. Like this huge company, huge company, and I can't think of the name of it, but they're coming after her, and she makes perfume in her sink. And she's like, what do they think I'm going to do? Like, take over their world? So yeah, you really do have to do those searches.
It's huge, and it's so important. And so that's exactly why I developed the course, because I have normally would do that on a one-to-one basis, and doing it one-to-one can be very expensive for people. Even though, I'll give you, just to draw a contrast between trademarking and copywriting, to register a piece of work to copyright, the filing fee is $35. To register a mark in one category is $325. So that gives you an idea of how much bigger trademarking is versus copywriting. The other thing is copywriting, there's no approval process. The fact that you created it and you register it and you affirm that you are the original creator, it's done. You do your application and you're protected. But with trademarking, it can take 12 to 18 months. Right now they're at over 12 months. Okay, 12 to 18 months for them to even review it. And then 18 months could go by and they may say, we don't think you've given us enough information to show us that you're really a big brand, so we want more, or we want you to give us more information. So it's a very scrutinizing process to get a trademark. And this goes back to, I like to explain the why behind things so that it makes sense for people. Again, remember I talked about how this being a country of freedom and the free flowing of ideas. And so before the government gives you exclusive rights to something that would restrict every other American from using it, they want to be sure that you really deserve it. You got to have something that's really strong for them to say no one else can use this. And so that's the premise behind trademarking. And so think about that when you're deciding whether or not you want to trademark something. The more unique that your name is, or your logo, or they love being where you're using something, a general word for a non-traditional use, like Apple for computer. I mean, that was like genius. It's like, Apple, who would ever think Apple for a computer? That's how they were able to get it, because the general word Apple, their government isn't going to restrict people from using the word Apple, but when it comes to compute anything in the electronic field, then that's going to be a little bit different. So those are the marks that have the highest probability of being approved and getting through and getting an actual trademark.
Okay, yeah, Tracy was just asking if we were going to have this typed out. I think what I'll do is, if I can find somebody on Fiverr who does, I know you can sometimes find them because they have like the programs and stuff, they run it through and they give you a minute-by-minute play. So I might do that. We'll see. But there will be a replay sent out, Tracy. So excellent. So tell us about your course. I'm going to go ahead and add the link to your course here. Everybody, there's a link for her course, her trademark course. Why don't you tell us about it, Tracy? Or, oh, now I've got Tracy on the mind. Sorry, Nikita.
Sure. So I'm really, really excited about the trademark course because, I was trying to find a way to make trademarking fun and easy. And affordable for entrepreneurs because it's so important, and so often people come to me on the backside of it when they've gotten the cease and desist letter from someone because they're infringing on someone's trademark or someone is stealing from them. So I decided to create this course. It is completely online. It's a digital course. It's going to be 6 weeks, but there's only 4 weeks of actual content. 2 of the weeks are implementation weeks, and the reason I did that is because there's a huge emphasis on the search. There are so many ways to search, and you want to do a very thorough search before you do your application, just to make sure that there's no confusion or no similarities between what you'd like to trademark and what someone else has already trademarked. So after we do the lesson on searching, we'll have an implementation week. And then I'm going to walk you step by step through actually drafting your application and filing it. And so I wanted to have a week of implementation to do that so that people can ask questions if they get stuck. This is a very technical course, and so I didn't want it to be rushed. So I really wanted to take my time and go through. First, we're going to start with just a basic overview of trademarks, what they are, how we use them, the different types of trademarks. And then we're going to get into the search. We'll actually go through this process step by step so that at the end you can actually submit your application. I'm going to give you information on the most common reasons that they are rejected so that you can be prepared for those up front so that you can make sure that your application is very strong. I'm going to do a special tutorial on international trademarks because so many of us are online and we're in many countries, and so there is a way that you can get trademark protection internationally. So we'll also go into international trademarks. And I'm going to have a legal advice clinic every Friday during the course so that you can ask questions as you are doing your searches and doing your applications. And even if you want to ask questions about other things, if it raises some other things for you in terms of legally protecting your business and your brand, I'll be right there to help you to get through that. So I really think, this course was really birthed out of my copywriting course where I did the same thing and I walked people through how to register a copyright, and everyone that took the course said, oh my God, I need to also do this, what about a trademark? And I thought, that would be a really great idea, and especially because trademarking is so expensive, and I wanted to show you if you do it this way, step by step by step, you have a much stronger chance of, getting it through and getting your trademark filed. And I think that there's just, like I said, there's just so many questions about how to do this and how expensive it is. A lot of lawyers probably charge anywhere from about $1,200 to $2,000, maybe a little more, to do the trademark application. And for a lot of attorneys, they charge you separately for the application than from the search, because it's possible that a search could be done and it's not available. So the search is usually, between $350 to $700, usually, to have someone do a comprehensive search, and then you have the application. So it could be very expensive. Plus, you've got the $325 filing fee for each category. I forgot to mention that in the first lesson, we're going to go through all the categories so that you can decide where would you like your mark. Where should your application go? Because that's another common reason for rejection, is that you put it in the wrong category. And there's like a million of them. So you want to just make sure that you have a good understanding of what each of the classifications are and which ones would be good for you and for your brand. The thing about the trademark application, if your application is rejected for any reason, you just get a notice of rejection. There's no refund, there's no money back, there's no do-over. It's just rejected, start over. So you want to make sure that you're doing it right from the beginning. So that's, another reason that I created the course. So I'm really excited about it. I would absolutely love to have everyone join the course. It's going to be really fun. I am also giving away as a bonus for early bird registration my copyright course. So the actual
Wow.
course, yes. So the course doesn't start until February 9th. But if you register before January 15th, you get access to the copyright course as well. So in the meantime, you can go ahead, take that course, and start registering your content. Register your website. Website is a number one. Every person that has a website should register to copyright that. And so I'll walk you through step by step how to do that in the copywriting course as well. And registering your blog articles if you're a major blogger. If you've got an ebook, you definitely want to have. So in the copyright course, I walk you through how to copyright your website and ebooks, because a lot of people are doing ebooks. And then if you've got a digital course, you may want to copyright that as well too.
Yeah, absolutely. Wow. If you guys haven't taken a look at the site yet, I'm looking at the site with all of the details of it, and this looks amazing, amazing. So the copyright course value is $297, so that's a really good bonus for signing up before, you said January 15th?
Yes, before January 15th. I didn't talk about the cost of the trademark course. So the cost of the trademark course is $1,000. You can pay that either one time, or if you need a flexible payment option, there is a flexible payment option. You can pay $250 per month for 4 months. It's the same price whether, however you do it. That's just my own personal thing. I'm not a lender, and I'm not extending you credit. If you pick the option that's best for you, the price is the same however you decide that you want to do it. So you would get, access right away to the copyright course, and that you would get that when you make your first payment of the $250. So really, you're getting the copyright course before you've even paid for the trademark course. So hopefully people will jump on that, and just let's empower ourselves to learn about the legal aspects of running our business, and let's just make 2015 the year that you really step your game up and start taking ownership of your business that you've worked so hard to build.
Agreed. Let's not see any more of this messy stuff going around. Let's just make sure that we're covered and cover our bases. So, I actually listened to a course about 6 months ago about trademarking, and they were offering to do, not including the search, not including any fees, not including doing the paperwork. It was the barest bones of trademark for you for $1,500.
I know.
So $1,000, and you learn a skill that then you can reuse for $1,000, and you get the copywriting course. That's actually pretty awesome. So yeah, that's a great course. So you guys should have the link there. Now let's just answer a couple more questions, and then we're going to have to get going here. You guys, we've taken you way over time here. Let's see. If you hire a graphic designer to create a blog post image or social post images and fail to have the contract in place, who owns the image? That goes right along with if you get something from Fiverr and they use a stock photo in your image, who owns the image? That's a great question.
Great questions. Okay, so if the owner of the copyright is the creator of the work. Okay, so when we hire graphic designers, if we hire a copywriter to write copy for us, the person who created the work owns the copyright. So before you hire any freelancer to do anything like that for you, you want to have a work for hire agreement in place. If you need a template for that, you can see me, and I can definitely get you a template for that. You want to have a work for hire agreement that says, I am hiring you to do this work for me, and so you are doing this work out of your employment to me, and so I will own the copyright. So that is so important. And when you go to register it, it will ask you that one of the questions that you've got to put in your application is whether this was what we call a work for hire, a work made for hire. Because under the Copyright Act, when employees do work within their employment, then the employer owns it and not the employee. And so you've got to, because we're hiring an independent contractor, we've got to create that employer-employee relationship, and we do that with a work made for hire or work for hire agreement. So that's very, very important. I'm so glad that you asked that question.
Does Fiverr have that in their terms and conditions that if
yes.
they do work for you?
Yes, so that's great. So if you have not downloaded my free guide on intellectual property, I talk about this, and I actually have the blurb that's on Fiverr's website. Fiverr, in their terms and conditions that we never read, says that that there is an assignment of the copyright at the time that the work is done. So the freelancers who do work on Fiverr are giving up their copyright when they create the work, and there's a transfer that happens to you. So if you did hire a freelancer on Fiverr, the work for hire agreement has already been done, so to speak. So you would own it. Great questions. I'm so glad.
Yeah, that's a great question.
Oh, let me put I'm going to put my website for my free guide.
Another question: how do you check if someone has a trademark? So, so we all know Kimra. We love Kimra.
We love Kimra.
And so Kimra said, when she came up with her Be True Brand You, which is amazing. It's when you were saying when someone comes up with something awesome, that's what I was thinking of, was Be True Brand You. She wrote that down or typed it or whatever she did, put a date on it, mailed it to herself. And she felt like that was trademarking it, and she put the TM after it. And now she's in the process of getting her trademark, which, as you said, can take 18 months to 2 years to get done. Is there an interim protection for yourself for those 2 years or however long it takes? Maybe you don't, for 2 years, you don't even have the money to get the trademark, so you're 4 years out before you can have a trademark. Is there an interim protection?
Wonderful, wonderful questions. Okay, so the first question is how you have to do a search for first. Okay, so if you do a search and you see that it's available, no one has trademarked it, and you want to trademark it, there are two types of trademark applications. One is an intent to use, meaning I got something so good, I'm not using it yet, but I'm going to use it. That's the intent to use application. And then you've got an in commerce, meaning I'm already using it, it's already out there kind of application. So you would file an intent to use application. You would say, I haven't used this yet, but I want to put this, I want to beat everyone to the punch. So what Kimra could have done is that when she came up with that, she could have done that. But what you described in writing it down and mailing it to yourself, that is actually not proper. It's called the mailbox rule, and it's what people used to do for copywriting. And because that would be their way, instead of registering with the U.S. Copyright Office, that would be their way of publishing, so to speak, or having a record of when they created it. But now we don't need to do that, because the copyright website is copyright.gov. You upload your work right there. It's only $35. So you can just register very easily and not have to do the mailbox rule. But the second thing that I want to say about that, what Kimra did, why that would not be what you would do also, is that you can't copyright words that don't mean anything. Copyright is for a creative work in tangible form. So that's a book or a poem. But just the words "Be True Brand You," they aren't going to be protected by copyright. They would be protected.
Do you trademark those, though?
Yes. There you go. You want to trademark that.
Okay.
Trademark that. And so so that's where that would come in. You cannot copyright a slogan, but you can trademark a slogan or a tagline or a program name or signature program. So that's what you would want to do for Be True Brand. You want to trademark it. Now, can you use the TM? You brought up a great question with the TM. Yes, the TM is, again, kind of like our copyright little C example. The TM, the purpose is to put the public on notice that this is your mark that you intend to use. But it has no legal anything. It has no legal protection. It's something that we do. Once your application has been approved and registered, you would use you've seen the encircled R for a registered trademark. So that's the deal with the symbols.
So you can't use the R unless you are registered.
There you go. You cannot use the R unless you are registered.
So the TM basically is putting them on notice.
Yes.
That it's yours.
Right. You want to do that. Let me just say this. You want to use the TM in conjunction with the intent to use application.
Gotcha. Okay, so that makes sense. Awesome. So then the question was, how do you know if someone already has trademark? Now there's websites where you do your searching, and there's like 5 of them, isn't there, where you do your searching?
I would tell you to use only the U.S. Patent and Trademark website, which is www.uspto.gov. Okay.
So I did that when I tried to use Leapfrog VA because I was really worried because Leapfrog, like the whole world knows about Leapfrog. But when I did the search, they use Leapfrog as 2 words. They don't have a VA, and I made sure that Leapfrog is 1 word with the VA actually attached. So Leapfrog VA is actually all 1 word.
Right.
And then I can use a Leapfrog VA network. And so the name of my company is actually Leapfrog Creations LLC, so that then I could sub everything else underneath it. Right. So I didn't have to do that for every single business that I had. And like you said, you don't know. I mean, how many businesses have I started? Right. A lot, but it takes 10 before you have 1 successful business, guys. That's what I heard. Exactly. And I'm proof of that.
Exactly. And I would say for you, that still might be tough. I mean, Leapfrog, and here's why. Because you're going to want to be in the education space, and that's where they are.
Well, actually, we're in different because they're in education. I'm actually in consulting.
Okay.
I'm actually in a different because what they do is they have electronic children's education, and I do online adult consulting and coaching. So it's actually different.
Okay.
But I have been holding my breath since I started it, thinking someday they could come after me. You know what? I honestly would just bow down and give them whatever they wanted, but hopefully they wouldn't take my house.
Right.
But I have been in terror of that for 4 years.
Here's the thing, and I don't, of course we'll get into this much more in the course, but the rule of thumb is always about the consumer and the consumer being confused. So would a consumer that saw Leapfrog VA think that Leapfrog has now gotten into the VA business? That's the question.
I don't think so. I think they're completely different. But
it's possible.
But they have more money than me. So they could prove otherwise.
Right. And if I could say one more thing about this, and then I know we got to go.
Yes.
The other thing about trademarks that's so important is that that you have federal trademarks, and then you have what's called common law or local trademarks. And so registration is when you are global or you're everywhere. If you own Nikia's hot dogs stand in DC, you may not necessarily need a federal trademark because you just need to be known right there where you are in your geographical area. So the reason why the trademark applications in that whole world has become so huge is because so many of us we're international and we're building much larger brands. And so, for people who are geographically located, it may not necessarily make sense for you to invest in a federal trademark because you've got to be able to prove that you are internationally, or you've got a brand where people would recognize you everywhere. And so that's that's the other piece of it. Just making
Well, I
sure.
actually am international. That's the problem.
Yeah.
I have business, I mean, I have clients all over the world, and I now have a Leapfrog VA Philippines, and I've been asked to create Leapfrog VA Australia, and who knows where that could go? I don't know. But the fact of the matter is that it's actually growing a lot fast. I had no idea what this was going to turn into when I first started it, really, and I don't think any of us do when we start our businesses. But this is definitely something that having the name that I have, really, really need to look into and get my things in order.
And isn't that the exciting part about being online? I mean, I can tell you, I was sitting here just thinking a year ago, I took B school this year. I had no, you could not have told me. You could not have told me for any amount of money that I would have 2 digital courses by January of 2015. I
Oh,
had no idea. I mean,
yeah.
it just happens, and that's the beauty of of online business. I love it. We all can be a global brand.
Yeah, I swore I would never do video. I'm like, I'm never going to do a video. Not in a million years. You couldn't pay me to do a video. And now I do videos like every stinking week. It's ridiculous. So, awesome. Well, Nakia, I think you're brilliant. I'm thrilled that we're in so many groups together, and that we've now gotten to chat in person, and that you've helped this amazing group who has joined us. And we will be sending out a replay. I'm going to push stop broadcast here in a second. Hopefully that will go through. But Nakia, I think you put your website up there, Nakia Gray, Nakia Gray, GRAY.com. You can get a hold of her there. She's in the groups. She's super active. If you have questions and you can't get a hold of her, let me know, and I'll make sure she gets them. But it's just amazing. This has been very, very inspirational and helpful for myself and obviously for everyone who joined us. So thank you very much.
Thank you so much. This was so fun. I love doing this. I would love to come back anytime and hook up with you and do it. I could do this all day. I love it. And, I'll say here, I am in the D.C. area, and it's a snow day. My kids are home. They're, like, locked upstairs because I told them they can't come down. But it's a snow day, and I just love that I don't have to go anywhere. It didn't rock my day at all. I can still sit right here. And as long as the internet connection works, which we were having some issues earlier, and it held up to get through this, which is great. I love that we can just continue working, and it can be a snow day, and I can still reach so many wonderful entrepreneurs online. I just love the online world.
Agreed. And I've been in a snow day. I used to live in Gaithersburg when I was little. I know what a snow day is like. Like, you wake up in the morning, like the night you go to bed at night, there's nothing. You wake up the next morning, you could have 4 feet in D.C. I'm telling you what, guys, D.C. is beautiful. I love D.C.
That's exactly what we did. I actually grew up in Montgomery County, so I wasn't far at all from Gaithersburg. Oh, that's so fun.
Who knows? Maybe we went to school together and we didn't even know.
Have.
I think I went to Jefferson. Was it Jefferson? What was the name of the school I went to? I don't even remember. Washington. I don't remember. Who knows? We could have gone to school together. I would have been the one white girl in class, which I was. I was the one. Actually, there were 2 of us there.
Wow. Wow.
But I loved it there. I did. But the weather is crazy there for sure. So, all right. Well, everybody, thank you, and everyone is telling you thank you as well. You guys have all been awesome. Great questions, great conversation, and maybe we'll do it again on another topic later. So
sounds great.
Sounds awesome. So you guys all have a great day. Bye, guys.
Bye-bye.